The subcommittee will come to order. Welcome to the Ways and Means Oversight Subcommittee hearing, which will serve as an update on IRS and DOJ efforts to return seized funds to taxpayers. Over the last 3 years, the subcommittee has undertaken tireless work examining the IRS's use of its civil asset forfeiture authority, including holding 2 hearings on this topic last Congress. Today's hearing serves as the third and will focus on the review process by the Department of Justice for civil asset forfeiture petitions referred to the department by the IRS. We remind our audience today how we got here. A few years ago, reports began to emerge that the IRS Criminal Investigation Division was seizing what appeared to be legally sourced funds based solely on allegations of structuring. By intentionally structuring currency transactions to be below the $10,000, taxpayers avoid reporting requirements set forth under the Bank Secrecy Act. To ensure individuals don't do this, structuring itself was made a crime. However, the law was not put in place simply so the government could enforce reporting requirements. It was put into place as a tool to be useful in addressing criminal behavior such as tax evasion, money laundering, terrorism, or drug trafficking. During the course of our investigation, the subcommittee heard from numerous small business owners who had their bank accounts seized for no reason other than making deposits under $10,000. There was no underlying criminal behavior, such as drug trafficking or money laundering. These seizures, as later confirmed by the Treasury Inspector General for Tax Administration, or TIGTA, were indeed primarily made against legal source funds, with the IRS compromising the rights of some individuals and businesses in the process. As a result, this subcommittee has worked with the IRS over the past few years to ensure better outcomes for these taxpayers. I won't say that these outcomes are fair or just, because many people spent years fighting the government over this issue, and some lost their livelihoods in the process. These are events that cannot be erased, and the years cannot be returned, but it's my hope that we can at least get these taxpayers their money back. While it may have taken a while, I was encouraged to see the example put forth by the IRS, which has gone beyond what was legally required to make things right. We've seen the IRS conduct extensive outreach to those who have a right to petition for the return of their funds. We've seen the IRS change internal policy to no longer pursue seizures solely based on structuring charges, policy changes that were made retroactive to assist those who first brought this issue to light. And ultimately, we've seen the IRS return the vast majority of the seized funds to taxpayers, recommending DOJ do the same. Which brings us to why we're here today. While I was pleased to see the IRS finally do what is right for most of the taxpayers caught up in this issue, I was discouraged to see that the DOJ has not taken the same approach. Although the department instituted a similar policy change to no longer pursue seizures solely based on structuring charges, it has elected not to make it retroactive. This decision harms the very taxpayers that it was intended to help. Furthermore, the department has chosen to deny all but approximately 16% of the petitions it received, despite the IRS recommending that 76% be granted with the funds returned to their rightful owners. As a result, I remain deeply concerned that taxpayers whose funds were seized solely based on structuring charges and whose petitions were referred to DOJ receive vastly different outcomes from similarly situated taxpayers whose petitions were reviewed by the IRS. In closing, I know today we may hear the argument that the law is the law and that structuring unto itself is a crime. But I would also remind the agencies here before us today that both of you have had documented instances, and in the case of the IRS, systematic process failures outlined by TIGTA that highlight the fact that these seizures were deeply flawed and at times unlawful. The rights of the individuals and small business owners at times were subverted, and yet it does not appear DOJ took any of this into account when it overwhelmingly denied most of these petitions. To that end, I look forward to hearing from our witnesses as we examine why DOJ has chosen to pursue this route, and I want to thank our witnesses for being here today, and I look forward to their testimony. I now yield to the distinguished member from Washington, Ms. Del Bene, for the purpose of an opening statement.
Thank you, Chairwoman Jenkins, for calling this hearing, and I'd like to thank our witnesses for appearing here this morning. You've both served the public with long and distinguished careers, and I want to thank you for what you do. I find it extremely timely to be participating in this particular hearing during this particular week. Because at the most basic level, today's hearing is a discussion about ensuring that our nation's laws are enforced reasonably, mercifully, and in a manner that does not offend our sense of justice. This session today signals at least some common ground between us, that when blind enforcement of the law leads to unjust or immoral outcomes that hurt people who don't deserve it, our federal government can change course, even if it has to move mountains to do so. On this subcommittee, it offended members' sense of fairness and decency to hear from small business owners who were deprived of their property because of the overzealous enforcement of the law. For years now, members have worked in a bipartisan way to push for justice for people who committed technical violations of the law, but who were punished with draconian consequences far in excess of what a reasonable person would consider just. Members showed empathy and concern to farmers and small business owners whose bank accounts were taken into custody, some might say caged. And members demanded answers from officials at the Department of Justice and the Internal Revenue Service, at times through high levels of tension and confrontation. And the committee drafted and marked up and passed legislation multiple times to address this injustice. And this body has the right to do so, because governments are imperfect, just like the individuals who lead them. And when we're wrong, they need to reverse course. Unjust policies should be challenged, stopped, and remedied. I look forward to the testimony of our witnesses, and I yield back.
Without objection, other members' opening statements will be made part of the record. Today's witness panel includes two experts, John P. Cronin, as Acting Assistant Attorney General of the Criminal Division of the U.S. Department of Justice, and Don Fort, Chief of Criminal Investigation at the Internal Revenue Service. The subcommittee has received your written statements, and they will all be made part of the formal hearing record. You each have 5 minutes to deliver your oral remarks, and we'll begin with Mr. Cronin. You may begin when you're ready.
Thank you, Chairman Jenkins, Representative Del Bene, and distinguished members of the committee. Thank you for this opportunity to address the Department of Justice's review of 256 petitions for the return of judicially forfeited funds in structuring cases investigated by the IRS. As the Acting Assistant Attorney General of the Criminal Division and previously a longtime national security and international narcotics prosecutor, I am privileged to represent the department today and to address our commitment to fighting crime in accordance with our law enforcement priorities and our highest ideals of justice and fairness. Money laundering poses an acute threat to the U.S. financial systems, where we enjoy the deepest, most liquid, and most stable markets in the world. But those very hallmarks also attract bad actors looking to launder their dirty money. The department is committed to keeping our financial system safe from money launderers and other criminals. But at the same time, the department has heard concerns raised by certain members of Congress about perceived overreach by law enforcement. And we have ensured that we are focused on the most serious criminal threats, including the most serious structuring offenses. The Bank Secrecy Act imposes several reporting requirements on financial institutions, including for transactions that exceed $10,000 in currency. Structuring, which occurs when an individual engages in transactions to evade a reporting requirement, causes the government to lose valuable information about potential unlawful activity and can often obscure serious criminal activity. For these reasons, Congress made structuring a standalone criminal offense. But let me emphasize, the law does not punish people for merely depositing $9,000 in a bank. It only punishes those who do so deliberately to get around a reporting requirement. If the government cannot prove that an individual intended to evade a reporting requirement, then that individual has not committed structuring. Congress has authorized various sanctions for structuring violations, including imprisonment, fines, and criminal and civil forfeiture of the structured funds. A civil forfeiture frequently is initiated by a judicially authorized seizure warrant that requires probable cause that the structuring occurred, the same probable cause standard required for an arrest warrant. Moreover, in a civil forfeiture based on a structuring violation, the government must prove by a preponderance of the evidence that the crime occurred and the property to be forfeited is linked to that crime. Even after a forfeiture is complete, owners, lien holders, and victims can seek return of property by filing petitions for remission or mitigation, which effectively are pardon requests for the property. Petitioners who themselves structure do not qualify for remission because they are not innocent owners of the property. Nevertheless, the department may decide that mitigation is warranted, a discretionary decision that is based on criteria set forth in federal regulations. Over the past 18 months, the department has conducted an exhaustive review of 256 petitions for remission or mitigation of judicial forfeitures based on structuring offenses investigated by IRS-CI. The department sought information and recommendations from both the local U.S. Attorney's Office and the IRS, and the department issued guidance to the U.S. Attorney's offices detailing the petition process, regulations, and required documentation. These procedures ensure that the Criminal Division's Money Laundering and Asset Recovery Section, or MLARS, was equipped to make consistent, even-handed decisions on all 256 petitions with a full picture of the facts. The department notified each petitioner in writing of our decision, including any bases for any denial as well as the process for seeking reconsideration. Reconsideration requests were then assigned to a different attorney and senior manager at MLARS for yet another layer of review. Although today I am not able to comment on any particular petition, I can provide a high-level summary of the results of our review. Of the 256 petitions received, the department granted 41 and denied 215. As the acting head of the Criminal Division, I am proud of the close attention and thorough review conducted by experienced and dedicated prosecutors in MLARS. All 256 petitions were reviewed pursuant to consistent standards, federal regulations, and in accordance with due process. Thank you, and I look forward to the subcommittee's questions.
Thank you. Mr. Fort, you're recognized.
Good morning, and thank you, Chairman Jenkins and members of the subcommittee. Thank you for the opportunity to appear before you today to discuss the implementation of policy changes concerning seizure and forfeiture activities involving legal source structuring. The IRS Criminal Investigation Division, CI, changed its policy with regard to legal source structuring cases on October 17, 2014. Under the current policy, CI does not pursue the seizure and forfeiture of funds associated solely with legal source structuring cases unless there are exceptional circumstances justifying the seizure and forfeiture and the case is approved by the Director of Field Operations. We have taken a number of steps to implement and enforce the new policy since its release. Our executives have communicated both the letter and the spirit of the policy to CI field personnel and asset forfeiture personnel through our intranet site, executive-led in-person meetings and conference calls, and a virtual town hall meeting. We've also updated our internal revenue manual to incorporate the new policy, and we believe the IRS's current policy strikes a proper balance between the needs of law enforcement and the rights of property owners. By concentrating primarily on illegal source structuring violations, we are able to devote our limited resources to investigating the most egregious federal violations, including those where the structuring activity is indicative of other more serious crimes. After the House Ways and Means Oversight Subcommittee hearing in May of 2016, CI proactively sent over 1,800 letters to property owners whose assets were forfeited based on structuring activity 5 years prior to the date of the policy change. In these letters, we advised property owners of the opportunity to file a petition for return of forfeited funds. We accepted petitions under this program until December 31st, 2016. In reviewing the petitions, CI followed the Internal Revenue Manual regarding remission or mitigation of forfeiture and DOJ regulations governing remission or mitigation of forfeiture. Based on the Area Special Agent in Charge's report and Criminal Tax Counsel's recommendation, the CI chief either reviewed and decided on the petition if it involved an administrative forfeiture, or in the case of a judicial forfeiture, made a recommendation through the respective United States Attorney's offices for consideration of the petition by DOJ. CI has sole discretion and authority to grant or deny the petition in an administrative forfeiture case. DOJ is the deciding official for each petition involving a judicial forfeiture. DOJ provided a copy of their final decision letter to CI in each judicial forfeiture case it reviewed. CI reviewed a total of 464 petitions, of which 208 were determined to be administrative forfeiture cases and 256 were determined to be judicial forfeiture cases. Based on the DOJ regulations and the IRS guidance set forth in the Internal Revenue Manual, CI granted relief with respect to 174 administrative forfeiture petitions and made a recommendation to the DOJ to grant relief with respect to 194 judicial forfeiture petitions. There were 5 judicial petitions received after December 31st, 2016. CI referred 4 of those 5 ultimately judicial forfeiture petitions directly to DOJ without a recommendation. For the 174 administrative forfeiture petitions granted by CI, all funds totaling almost $10 million were returned to petitioners. Chairman Jenkins and members of the subcommittee, I appreciate the opportunity to testify here this morning on this important topic, and would be happy to take your questions.
Thank you. We'll now proceed to the question and answer session, and I would like to direct my first question to Mr. Fort. Each of your agencies was responsible for reviewing a portion of these petitions. Can you provide us with a brief overview of how many petitions were referred to DOJ and how many IRS recommended DOJ grant or deny? My rough math tells me IRS recommended that DOJ grant about 76% of the petitions. Is that correct?
So on the judicial petitions, there were 246 that we received. We recommended to the Department of Justice granting 194 of those petitions.
Okay, Mr. Cronin, of the petitions DOJ received from IRS, how many of these were granted and how many were denied? Because again, my rough math tells me about 16% were granted. Is that correct?
The 41 were granted and 215 were denied. I couldn't tell you the percentage off the top of my head right now, but I believe 16% seems about right.
And you each have completed your petition reviews, is that correct?
That's correct.
That's correct.
Okay, Mr. Cronin, what is the status of the cases underlying these petitions? Are they closed? Are they open to additional criminal charges?
My understanding is that they would all be closed by this point.
For those who were not satisfied with the outcomes of this petition process, what additional actions are available to them? For example, can they still re-petition DOJ?
At this point, those individuals would have received a letter from DOJ, have received letters from DOJ explaining the bases for denial of their petition. Those letters provide specific information as to why the petitions were denied, and those letters also provided the petitioners with an opportunity to submit additional information and seek reconsideration. 36 individuals sought reconsideration. Of those 36, less than 5 of them provided any new information, and as of earlier this year, as of April, all those reconsiderations were denied, so we are complete with the process.
Okay, Mr. Cronin, what would a petitioner need to provide DOJ for it to reverse a denial of a petition for remission or mitigation?
It would depend on the specific reason for denial, and it's kind of tough to speak generally, but if they would have a basis for contradicting a reason for the department's denial of their petition, that information would be relevant. Under the federal regulations, the burden is on the petitioner to establish a basis for mitigation. That's pretty clear. That's clear under the regulations, and in the initial petition, that's when they have the opportunity to present the reason for mitigation. We then give them a second shot at reconsideration to provide additional information for us to consider under the applicable regulations.
Okay, thank you. I now recognize Ms. Del Bene.
Thank you. I have a question for both of you. I'd like to know what are your views on the responsibility of the federal government to balance enforcement of the letter of the law with the pursuit of justice? And based on your experiences with this program, have you observed that the federal government is capable of reversing a mistaken policy that imposes draconian punishments on people who don't deserve them? And if so, how does that happen?
Well, Representative Del Bene, as a longtime federal prosecutor, I fully appreciate the importance of prosecutorial discretion. I very much understand that just because a law is on the books, you have to look at the specific facts of an individual case to determine what route to take, whether to pursue an investigation or a prosecution. The decision to commence an investigation and prosecution is one of the most important decisions any prosecutor makes. I think when you look at these cases, and again, I can't speak about individual cases, you repeatedly do see elements of prosecutorial discretion here. There were situations where criminal charges could have been pursued, where there was evidence of a violation of a criminal statute, but criminal charges were not pursued. There were civil settlements that were entered into that were a tiny fraction of the total amount that could have been forfeited. At that settlement point, mitigation considerations were taken into account. And also, you see in the March 2015 policy, the Department of Justice took a prospective look going forward, how to best allocate its limited resources to ensure that those resources are being best focused on the most serious structuring offenses. So to answer your question, prosecutorial discretion is extremely important, and I do think we've exercised that here.
So I would agree, and I would say we are certainly capable and did demonstrate in this case that we're able to reverse course. And I heard the committee, the testimony before this subcommittee and the witnesses that testified before this subcommittee. We changed our policy in October of 2014. I believe we were the first law enforcement agency to do that. And taking it a step further, after the testimony before the subcommittee in May of 2016, we made the decision to go back 5 years from the date of policy to provide redress for those property owners whose funds would not have been seized under the current policy that was set forth in 2014. And since the date of the policy going back almost 3.5 years, we've had a total of 32 structuring seizures, illegal structuring seizures approved in that 3.5-year period of time. I'm very proud of the work that we've done in timely and expeditiously addressing all the petitions that were sent in. As I mentioned, well over 400 petitions that were sent into the IRS, and deciding expeditiously on those or sending our decisions to the Department of Justice.
Thank you. So it seems that it's both of your conclusions at the end of this process that the federal government can successfully reverse a flawed policy when it imposes a devastating hardship on people who have only committed a minor infraction. Is that a fair summary?
Representative, I will say that the Department of Justice regularly does evaluate its prosecutorial law enforcement priorities and can adjust its policies in accordance with that. That's not necessarily a reflection that the prior policy was wrong or improper, but a prospective look going forward as how the department should allocate its resources.
And again, we, changing our policy in 2014, recognized that we needed to focus our limited investigative resources on the most egregious violations. And again, by going back and applying our policy retroactively for 5 years, we demonstrated that fact, I believe.
Thank you. I yield back.
Ms. Walorski, you are now recognized.
Thank you, Chairman Jenkins, for holding this important hearing. Mr. Cronin, can you discuss the standards that the DOJ used when reviewing the petitions for remission and mitigation?
Certainly can. The standards are reflected in the federal regulations, 9.31 CFR 9.5.
Can you just summarize those?
Absolutely. They provide a few things. First, they provide for both remission and mitigation. Remission in most cases was not an option because in most circumstances the petitioner was not an innocent owner. So we were looking at mitigation. The regulations provide that it's a burden on the petitioner to establish a basis for mitigation. And then the regulations provide a list of 5 non-exclusive factors to take into consideration. Those are lack of a prior record or similar conduct, whether the person has taken steps to prevent future criminal conduct, whether the violation was minimal and not part of a larger criminal scheme, whether the violator cooperated regarding the conduct that was underlying the forfeiture and here the structuring offense, and a general consideration of whether complete forfeiture is necessary to achieve the legitimate purposes of forfeiture. So those were the general considerations we took into account, and then we applied a holistic totality of circumstances evaluation, looking at that case and more broadly other similar cases, so we're able to reach consistent and appropriate results.
I appreciate it. And Mr. Fort, can you discuss the standards the IRS used when reviewing those petitions?
Sure. So we use the same standards as Mr. Cronin just laid out, and I won't restate those for the subcommittee. I will say the process, to go in a little bit more detail, any petition that was sent to an IRS field office, to a special agent in charge, who took certain steps before a package was sent up to the chief of CI to render a decision. So they looked at the petition, they had access to the petition, looked at the petition, they looked at whatever was in the investigative file and did minimal, non-intrusive investigative steps, such as running a current criminal history check and any available public record information. Then they packaged that information with the recommendation of our Criminal Tax Counsel, sent that up through our headquarters, and the chief of CI was the one that actually looked at those factors, again, that Mr. Cronin laid out, and rendered a decision in the administrative cases or made a recommendation to the Department of Justice in the judicial cases.
I appreciate it. You're both listing the same criteria, more or less. There's a wide discrepancy in the percentage of petitions granted. IRS recommended that DOJ grant 76% of the petitions, but DOJ only granted 16% of the petitions. How can we say that you're all looking at the same evidence, using the same standards, but reaching the opposite conclusion so often?
So I can say with respect to the decisions that we made or the recommendations that we made, because I personally reviewed many of these and signed them myself, we decided to give more weight to one particular factor, and that was whether it was a minimal violation or part of a larger criminal scheme. And we did that because that most closely aligned with our October 2014 policy to only pursue seizures of illegal source funds. And I'll also stress that, going back to what I testified to a minute ago, the agents and the special agents in charge in the field offices were going on only the investigative information that it was in the file. We did not open and conduct additional investigations.
And Mr. Cronin?
I'm not in a position to speak about the review process at the IRS, but I can speak about the review process.
How can the results be so vastly different when you're looking at this? What's DOJ doing that IRS isn't doing?
What we were doing is taking a close look at all the relevant facts in the case, a comprehensive, thorough review. By the time the petitions would get to the Department of Justice's money laundering and asset recovery section, we had the benefit of all documentation that would be relevant, the benefit of recommendations from the U.S. Attorney's Office and the IRS, and also there were circumstances where our review I would have likely looked at stuff that might not have been part of the IRS's review, such as whether or not there was ongoing structuring conduct by the petitioner, such as whether or not—
Let me interrupt for 1 second. That's where I think this gap is unbelievable, because what you're saying is what the IRS gave you, 60%, that 60% gap are basically because people had criminal records.
Well, I think it's hard to say that the basis for the 60% gap without going into individual details on each case, but I can say globally there were numerous different broad categories that the petitions fell into, whether it be evidence of other criminal activity, evidence of ongoing structuring and failure to file required forms under the Bank Secrecy Act.
I got to stop you right there. I apologize.
Yeah.
Thank you, and Madam Chair, I yield back.
Thank you. Mr. Bishop, you're recognized.
Thank you, Madam Chairwoman, and thank you, gentlemen, for being here today and sharing your testimony. Mr. Cronin, you used words like deliberately and intended regarding the criminal investigation process. Those are words of art in the law. They suggest a specific intent crime. And I'd like to just ask you, your process in investigating and the evidence, the threshold necessary. I'm reading that probable cause that the structured funds were generated by unlawful activity, that the structured funds were intended for use in or to conceal or promote ongoing or anticipated unlawful activity. What evidence are you looking at? What typically do you look at? Behavior? What kind of evidence?
Thank you, Congressman. I assume you're talking about at the time of the original.
Yes, sir.
What the prosecutors and the agents will be looking at that time is evidence that there were transactions conducted with the intention of evading the reporting requirements under the Bank Secrecy Act, and here in particular we're dealing with currency transaction reports, CTRs. And the way that is proven in cases varies, but often it's by looking at a series of bank activities. You may see, for example, multiple cash deposits on the same day between $9,000 and $10,000. That's a pretty clear indication that structuring is going on. Doing that just one time, just one deposit of $9,000 is not structuring. We look at a pattern activity, and that's what we had in these cases. Sometimes a very long pattern. Many of these cases involved over $100,000 in structured funds over a 12-month period. And the other thing is based on statements made by the individuals who were suspected of engaging in the structuring activity. Repeatedly, there were statements made that were made along the lines of, yep, I knew I had to avoid making a deposit above $10,000 because that would require a report to be filed. Those were the types of things that the prosecutor will be looking at.
Okay, thank you. Mr. Ford, I'm also looking at your 2014 IRS criminal investigation changes that you made. And in this case, it appears as though you use the standard of exceptional circumstances, which I've not heard of before. And I'd be interested to hear what that means. Exceptional circumstances justifying the seizure and forfeiture, and the case has been approved at by the Director of Field Operations.
Yes, thank you, Congressman. As I mentioned a few minutes ago, we have not had any exceptional circumstance memos approved at the chief's level. It's not defined, but typically it would be extremely rare in the interest of national security, something of that nature, but we have not had any, we have not approved any. The Director of Field Operations level, the reason that was done is to elevate the approval level of those particular cases, and the Director of Field Operations level is the frontline executive that oversees all field operations in the field.
In your mind, is exceptional circumstances higher than probable cause in terms of a standard?
Yes.
Evidentiary standard?
Yes, and you know, as I mentioned, we've only approved 32 illegal structuring seizures since the date of the policy, and have not had any exceptional circumstances. But it would again deem to me to be in the interest of national security, or funds were going to be dissipated overseas in international, something of that capacity.
Okay, thank you. I have a quick question, Mr. Ford, on the subject of review process of petitions for remissions and mitigation. There's a process by which owners, lien holders, victims can seek this process, forfeited property. Can you just tell us quickly how that works?
Are you talking about the process by which we went back?
Yeah. How do you notify these folks?
So we went back in this process. We went back through our databases of all cases in which we had seized funds under a structuring violation. And the only category of individuals we excluded were those that were criminally convicted of a structuring charge. We identified well over 600 individuals, and we sent out 1,800 notices to anybody who may have an interest in that property.
Of that group, how many actually responded? How do you know you actually?
We had, so we had, and I think I misspoke at the beginning, we had a total of 464 total petitions that we received from the notices that we sent out.
Of how many? Of how many altogether was it again?
We sent out 1,800 notices,
okay, and then 400.
On close to 700 cases. So in one particular case, you could have notice to 2 or 3 potential individuals that may have a property, that may have a right to that particular property.
Thank you, sir. I yield back.
I now recognize Mr. Winstrup.
Thank you, Madam Chairman. And thank you for being here. My first question is, until you've gone back and done some of this retroactively to seemingly right some wrongs, do you ever feel like the agency ever acts parentally, or is it always just punitive? In other words, do you ever go advise someone, or do you just come in and seize their property? Do they ever get a warning? Do you ever say, hey, this doesn't look right? Or is it just immediately show up at the door and say, we're going to take away your assets?
Thank you for the question, Congressman. We do have a process where we advise individuals of potential criminal wrongdoing. And, you know, I think in this case, where we've corrected and fixed our procedure, we don't just go out and seize individuals' funds, particularly as it relates to legally, what we believe to be legally derived funds. And, you know, one of the reasons that we changed this policy was to really allocate our limited resources to the most egregious criminal violations. So we still look carefully at all structuring and Bank Secrecy Act violations, but more as a potential indicator of a violation of another larger criminal scheme.
Yeah, because it seems like a lot of the cases that we read about previously, and hopefully this is improved, people were guilty until proven innocent. I mean, it was on them to prove their innocence, and in the meantime, their businesses are closing down, et cetera. Let me ask you, do you think it's good business policy to have more paperwork based on amounts of deposit and a crime if you don't? I mean, it's perverse incentives here for people.
I'm sorry, Congressman, I don't know.
Well, you know, there's going to be more requirements if you deposit over $10,000, and yet you're punished if you're under $10,000. You know, I'm a doctor. I started with my own practice. You know, some days you didn't have much to deposit, but you don't want to hide it under your bed. And so how many deposits are you going to have under $10,000 in a small business? And that's a crime. I don't understand that. I mean, it seems to me that's a pretty perverse policy there.
So again, having, you know, changed our policy, we, you know, carefully review, you know, the Bank Secrecy Act information, and agents, you know, make those determinations as to whether or not it may be an indicator of another criminal violation, or in and of itself, the activity is we believe, and we've documented that it's connected to an illegal source.
And that I understand. So one other question, have any of the seizures where the person ended up being innocent of a crime resulted in any punitive damages against the agency that accused them and maybe took away their business and took away their income? Did they ever get their income back and punitive damages, or just the income that was removed?
Sorry, I'm not aware of any punitive damages.
So there isn't much liability on the agency when it comes to these decision-making process. So you can be wrong and doesn't harm you at all.
Not being an attorney, I can't answer that question, but I'm not aware of any punitive damages against the agency.
Okay, thank you. I yield back.
Congressman, being attorney, I think I might be able to answer part of that question. With respect to the judicial forfeitures at issue, I would just clarify that none of them were unlawful. They're all lawful forfeitures. But the Congress has passed a statute, the Civil Assets Forfeiture Reform Act, that does allow for attorney's fees and litigation costs against the government where a claimant substantially prevails in a civil forfeiture action. So if a claimant prevailed during the judicial civil forfeiture proceeding, there is an opportunity to recover, but that's not the situation we're in here.
So it recovers the expenses, but not necessarily any additional damages?
I believe it's attorney's fees and litigation costs. I don't know if that statute allows for more than that.
Thank you.
Thank you.
Mr. LaHood, you recognized. Mr. Roscom, you will be recognized. Oh, Mr. LaHood? Yes. Mr. LaHood is recognized.
And thank you for your testimony here today. I want to focus initially on the Treasury Inspector General for Tax Administration, or TIGTA, report from March of 2017. And in that report, it was found there were many concerns with the IRS's enforcement of structuring laws that it recommended in that report, quote, in light of the fact that some property owners may be reluctant to again engage the government and may not file petitions, or that the Criminal Investigation Division may again treat property owners who do file petitions inconsistently, that the criminal investigation should simply return the forfeited funds and recommended DOJ to do so in judicial cases, unquote. Additionally, in that report, TIGTA had findings such as, number one, most seizures for structuring violations involve legal source funds, even though the Criminal Investigation Division Civil Forfeiture Program exists to interdict criminal enterprises. Number two, interviews with property owners did not meet all IRS requirements, and most individuals weren't advised of their rights. Number three in the report, when property owners provided realistic defenses or explanations, the IRS did not consider them. And fourthly, the outcomes for legal source cases lacked consistency. Now, that was four of many things that were in that report, and I could talk about a number of those other ones, Mr. Cronin. I guess my question is, was DOJ aware of the TIGTA audit findings when it reviewed the petitions in question?
Congressman, I joined the Department of Justice in this past August. Previously, I was at the U.S. Attorney's Office in New York, so I hesitate to answer that question because I do not know for certain, but I would be happy to look into that and follow up.
Well, I mean, maybe you can comment on those concerns raised by the IG. Tell me how they've been taken into account by the Department of Justice.
Well, in looking at the mitigation and remission petitions, we looked at a variety of factors, like I mentioned, and one of the factors we would consider would be conduct by the AUSA and/or of the agent. So that would be a factor that we would look into.
And before I get to my next question here, can you comment, Mr. Cronin, on whether at the, I guess, the federal circuit level or in any other OIG report, has there been scrutiny or criticism at the appellate level for AUSAs or the federal government going over the line or being inappropriate related to prosecutorial misconduct?
Congressman, I'm not aware of any criticism, but I do not know for certain. And again, I'd be happy to look into that and follow up, but I'm not aware of any decision as I'm sitting here today.
Generally speaking, when DOJ knows that a seizing agency did not conform to the laws, regulations, or policies governing civil asset forfeitures, does DOJ consider this information when deciding whether to grant or deny a petition?
It's hard to speak generally, but it would be a relevant consideration if there was inappropriate action by an AUSA or an agent in reviewing the mitigation process.
Well, I think you referenced earlier that it may not be, and that was part of the issue why we're here. But it appears that we have, a little bit of an interesting situation here. On one hand, the IRS, made significant mistakes in the seizure process. However, it was limited in the types of petitions it could grant and had to refer some to DOJ. But DOJ is prohibited from taking the IG's findings into account. So I guess looking at what's the solution here moving forward?
Well, I think, Congressman, it's twofold. One of the solutions moving forward is a policy change by the department in March 2015 going forward, and that change makes clear that if criminal charges are not filed in a case, then prosecutors may not seize structured funds unless there's probable cause that the funds originated from criminal activity, and that must be approved at a supervisory level, or there's some compelling law enforcement interest that must be approved at the U.S. Attorney or the Chief of the Money Laundering Asset Recovery Section. So going forward, we have that protection. Looking back, we had the process of reviewing the 256 petitions for mitigation and remission, and that was a thorough, comprehensive review that looked at a variety of facts and criteria. And in looking at many of those petitions, we found a number of circumstances that made further mitigation not warranted.
And just one last follow-up on there. That new policy is proactive. It's not retroactive, correct?
That's correct.
Thank you.
Mr. Roscom, you're recognized.
Thank you, Madam Chairman. Thank you for allowing me to sit in today. Mr. Fort, my compliments to the IRS. I think you've acted forthrightly when this has come to the agency's attention. The Commissioner apologized, changed policies, and was incredibly proactive, and I want to acknowledge that publicly. Mr. Cronin, you said something interesting in your written statement. It was in the third paragraph. It was a phrase that caught my attention, and it's important to you because you emphasized it again in your oral statement, and that was, these are the most serious criminal threats, that the department has evaluated this in light of the most serious criminal threats. Now, based on your background and just looking at your bio is involved in 9/11. Your bio is involved in international narcotics rings. You're not making the representation to this committee today that this rises to that level, are you? Surely these types of cases that are de minimis at best are not the most serious criminal threats. Do you want to revisit that phrase?
Congressman, I apologize if I wasn't clear, but when I refer to the most serious criminal threats, I'm talking about the department's focusing its efforts post the March 2015 policy and ensuring that we are focused on the most serious structuring offenses. Now, I do think structuring is something that is...
We agree, and we will stipulate that. But now, why not, if you're focusing in on the most serious threats, why not follow the department's own standards, that is, in mitigation? So you take cases that allow mitigation in certain petitions, and yet, and these criterion that are your criterion in mitigation, lack of a prior record or evidence of similar conduct, violation does not involve drug distribution, manufacturing, to prevent further criminal conduct, the fact that the violation was minimal and not part of a larger scheme, the fact that the violator has cooperated with state, federal, et cetera, and the fact that complete forfeiture is not necessary to achieve a legitimate purpose of forfeiture. Surely these cases that the IRS reviewed, that the IRS was closest to, that the IRS recommended to the Department of Justice that they release those funds, why is it that the Department of Justice didn't follow its own regulations? And just for the record, you didn't do these cases, did you? You're just being provided talking points today, is that right?
Congressman, when I joined the department in August, I was brought up to speed as to this issue, and ever since then, I've been closely monitoring this issue and meeting with our money laundering and asset recovery section.
Okay, if that's true, then why not follow the department's own regulation in mitigation?
Congressman, we have been following our own regulations, and when applying those regulations, we found time and time again reasons to deny the petitions. We found...
Look, let me draw your attention to a case I will comment on, you won't, but this is the case of Mr. Kwan, who in the admonition, in the denial letter from DOJ, they said he pleaded guilty to criminal structuring, which that's the underlying case, fine, but there's no other mention of anything in terms of why he shouldn't get his money back. And yet the representation you made moments ago was that this was all explained to these clients or these people that have been caught up in this mess. And yet there's no description that's consistent with your own standard in mitigation. Why is that?
Well, I think a criminal conviction would be consistent with that standard. There were cases where someone has been convicted in a companion criminal
No, it's not a
case.
conviction. It's a guilty plea. And you know how this guilty plea went down. If you evaluated the files, if you got up to speed in terms of the briefing, you're familiar with this case. So this is a case where the DOJ comes, Mr. Cronin, to somebody, and they put big muscle on him. And they say, you've got two choices, immigrant businessman. We're either going to bring a file against you or we're going to take your business away. And you know what? In this case, the DOJ did both. And now this guy is broken. And you're making a representation to this committee that this is part of the most serious criminal threats. This businessman in Northern Virginia is somehow involved in the most serious criminal threats? That's obtuse. And how is it possible that the agency that is closest to these cases, that is the Internal Revenue Service, that initiated the cases, that brought the cases, that pursued the cases, and then refers them, knows less about these cases than the Department of Justice? How is that possible?
Well, first of all, the regulations put in the responsibility of the Department of Justice to make the decision on judicial forfeitures.
Yeah, but you just represented that you were taking into consideration what the Internal Revenue Service has brought to your attention. Why the denial, to Ms. Walorski's point, in terms of the number of these cases that are denied? What is it about the Department of Justice on these cases that is so obtuse?
Well, there were cases where we found evidence of tax evasion, nexus to black market peso exchange, to trade-based money laundering, evidence of fraud, a drug nexus to property, continued structuring, continued violations of reporting requirements.
I challenge the department to make the representation about these in some of these specific cases. When I had a briefing a couple of weeks ago, there were two factors that were brought to my attention, and I agreed. I said, listen, if that is the fact, then fine. There's nobody that's quarreling about that. But the notion that Mr. Kwan or Clyde, Mr. Andrews, these other cases where there's an innocence, I'll tell you what's happened. And in some of these cases, an AUSA crossed the line. And there's been not a level of discipline that has come to this committee's attention when the AUSA says, in writing, the reason that we brought this case is because your client talked to the press. Your client asserted a First Amendment right. This is my paraphrase. Has there been any level of disposition on that in terms of AUSA abuse, Mr. Cronin?
Well, Congressman, of course, aware from the prior hearings of the allegations that have been made with respect to certain AUSAs. I'm also aware that you have been in communication with the department regarding those matters. As I'm sure you know, that falls within the office.
Communication presumes two-way, Mr. Cronin. Making inquiries and being stiff-armed by the Department of Justice is not communication.
Well, I believe the Office of Professional Responsibility provided a briefing to your staff regarding the matter. But
what's
I can
the disposition?
report here.
What's the disposition of those cases?
I cannot speak to the disposition of the case. I can tell you, Congressman.
Has anybody been disciplined?
I can tell you that the cases were reviewed by OPR, and those OPRs have been completed and disposed of. For privacy reasons, obviously, I'm sure you understand, I cannot talk about the dispositions of individual personnel matters.
I see. So it's been reviewed by top people. Mr. Cronin, my time has expired. I think that the way the Department of Justice has approached this is not admirable. I think that the way the Internal Revenue Service has approached this is admirable. You're not in the muscle end of the family. You're a guy who's brought in here, you read a file, you get some briefs, and they sent you out here. You're defending something today that is indefensible. And the notion that people at DOJ have this kind of power and this kind of discretion and can run roughshod over innocent people and basically get stiff-armed and say, well, you pled guilty and now we're going to use your guilty plea against you, even though we manipulated a guilty plea, that's shameful. I yield back.
Mr. Lewis, you are recognized.
Thank you, Madam Chair. Madam Chair, I had to be delayed because I felt very, very strongly within my soul that we had to do something about the children. There's hundreds and thousands of children, little babies, that have been taken from their mothers, from their fathers. They've been held in cages. It's not right. It's not fair. It's not just. My position is very simple. History will not be kind to us as a nation and as a people if we continue to go down this road. In the final analysis, we are one people, we're one family. We all live in the same house, not just the American house, but the world house. And it doesn't matter whether we're black or white, Latino, Asian American, or Native American. Maybe our foremothers and our forefathers all came to this great land in different ships, but we're all in the same boat now. What is happening in our country today will set us back for many, many years to come. We must end it, and end it now. Free and liberate these children. That's the right thing to do. And I yield back.
I want to thank our witnesses for appearing before us today. Please be advised that members have 2 weeks to submit written questions to be answered later in writing. Those questions and your answers will be made part of the formal hearing record. And with that, the subcommittee stands adjourned.
Oh, yeah.